Justice of the Appellate Division Court Department, hear ye, hear ye, hear ye. All persons having business before this court will draw near with their attendance and shall be heard.
Oh, excuse me. Excuse me. Thank you. Please be seated. The first case out for argument today is case 137, People versus Bird. Counsel, can you hear us?
I can't hear you. Can you hear me?
And we can hear you. I'd stay close to the microphone, though, because you're sounding a little garbled, and it might be easier to hear if you're closer to the microphone. But counsel, please. Counsel, are you're appearing on this case?
Yes, Your Honor.
Very good. Do you want to sit at counsel's?
Yes, I will. Thank you.
Sure.
Good morning. May it please the court. Ed Keem and I represent Tyrone Bird. We assert that the waiver of appeal was invalid. The trial court mischaracterized the nature of the right to appeal. It also omitted the exceptions to the waiver. Although waiver form was utilized, it did not cure the defects here. So we'd ask the court to take a look at our issues that we presented. One of those issues is the withdrawal. And in regard to withdrawal, it's important to remember appellant was 18 years old, limited education. He just learned that Judge Cuffey and Judge Doran had involvement in his assault second-degree family court case, creating some mistrust there.
Are you saying that, there's a preservation issue here? Is that what you're addressing now, counsel?
I am well, first, we argue the waiver. Second, the preservation part would be the interest of justice because he didn't have real defense counsel. Defense counsel and appellant couldn't communicate. So defense counsel didn't make the motion to withdraw. Appellant was forced to. And appellant's request wasn't the most clear here, but he did explain that he didn't understand the consequences of the plea and that he never wanted to testify against his co-defendants.
Okay.
The trial court...
Mr. Keene, correct me if I'm wrong, but wasn't that explicitly explained to him in the plea colloquy? That one of the consequences of the plea was that he was expected to testify against his co-defendant. Clearly stated. Yeah.
It is in the plea colloquy. It is clearly stated, but I think that subsequent to that, you have some strong evidence on the record that defense counsel and appellant were not communicating, and that appellant's true desires were reflected on this secondary transcript where he asked to withdraw. And then he didn't have help when he asked to withdraw. He had to do it on his own. And the trial court's response really was to not ask for any questions, okay? And then to not ask, in regard to the replacement counsel part, the trial court said that he did a great job in this kind of case, getting him the deal that he did. And that response by the trial court, we would assert, demonstrated his abuse of discretion in not only the withdrawal, but then the replacement counsel aspect of our point as well.
Okay.
If there aren't any additional questions on that issue, I just would like to address the sentence briefly. I understand that appellant didn't testify like he said that he would, but he was 17 at the time of the offense. His participation was holding a BB gun. He used it. Gathings and Webster received 10 years as a result of their participation, which we assert was closer to Bird. And, considering his lack of experience, his age,
What about his prior, Mr. Keene? Didn't he have a serious prior where he participated in what they referred to as a knockout game with a 51-year-old victim?
Yes, absolutely, Your Honor. And that I think is reflected in the 15 instead of 10. Okay, 30 years that they for holding a BB gun. It's a bad choice that he made, but he's young enough.
Yeah.
I'm sorry. Go ahead, Justice Bannister.
Could you look at it that, the 15 was based on his promise to help get the other participants convicted, okay? And when that went away, now we have just his history to look at when it comes to a sentence, I mean, I guess I'm saying that there's an argument that he got the benefit of, with the 15, of the bargain that he made to testify against the co-defendants, which didn't happen.
I understand that, Justice Bannister, but I think doubling it to 30 years from that 15 was severe. I understand his history, but when you look at his age, his mental health, going from 15 to 30 for his failure to testify, I don't think was fair under the circumstances.
Counsel, we'll take a look at the
Reduce
sentence.
the sentence, unless there's, thank you, Your Honor.
All right, thank you, counsel. Counsel?
Elizabeth Dannon for the people. Your Honors, we would just reiterate what we have put in the brief, that the judges in question were not even aware of their involvement prior to looking at the pre-sentence report after the plea was entered. So they were not required to recuse. They both did so, and any further proceedings were under another judge. The judge that took the sentencing, the defendant asked to withdraw his plea on the date of sentencing after his counsel had specifically said that he had made a motion. There was a motion to be made. He advocated to withdraw the plea. The defendant refused to do it. It was obviously a important choice within the defendant's purview to make that choice. The counsel could not make it for him, and when asked why he wanted to withdraw the plea, defendant made conclusory allegations of not coming to see him enough, that he didn't, he felt that the counsel spoke bias-like to him. There was no specific factual reasons given for the counsel to recuse himself at that point. Counsel,
I have a question.
Yes.
All right, to the last point raised by
Yes.
Mr. Keeman, that's the sentence. I mean, his point is, okay, defendant was holding a BB gun. Now, of course, at the time, the victim didn't know that it was a BB gun. Okay, granted that. But he's 17, and he's going to be in jail for 30 years. How do you explain such a harsh sentence for the person who didn't even pull the actual trigger?
Your Honor, the defendant was 18 years old when he decided to defraud the court, to not speak and not help to convict his co-defendants as he had said he would. And that is explicitly why the prosecutor in that case advocated for the long sentence. He specifically said it is not because of his involvement in that specific case that we're advocating for a longer sentence. We are doing it because he was told on multiple occasions he was debriefed, there was sworn statements that he swore to, and that the court viewed ex parte, and the defendant was thoroughly explained what the consequences of his failing to testify were. And I would state that, and I would put on the record that part of the reasons that his co-defendants did not get as long of a sentence is because this defendant refused to testify, and he did that long after the events in question.
Okay. Thank you.
Thank you, counsel. Case 138, People versus Bish. Proceed, counsel.
Good morning, Your Honors. May it please the court, Carrie Connor on behalf of Appellant John Bish. Mr. Bish was denied his right to a speedy trial under CPL 3030, where more than 183 days were chargeable to the people. Today I'll be focusing on the most significant period of time, which involved an adjournment requested by the people. The people requested an adjournment of the October 25th.
Is this the Huntley hearing adjournment you're
Yes,
talking about?
that's correct.
And in this particular case, the court charged, 23 days?
23 days out of the 88-day delay.
And
correct.
you're saying that it should have been 83 days, is that right?
88 days.
88 days?
Yes.
Okay, 83, I came up with 83, but okay. That's November 1st to 30th, or to January 22nd. That's what you're talking about, right?
It's October 25th to January 22nd.
That's where we differ. Okay,
Yeah.
very good. So the people have the burden to prove the cause for the delay, and you're saying essentially that the record here fails to demonstrate the reasons for why the delay was not chargeable to the people, and because of their failure to prove, those days ought to be credited.
That's correct. The people have the burden of showing that the time periods are excludable, and they also are required to state on the record the reason for an adjournment that they request. And since they failed to do so, then yes.
So even if we combed the record and found additional information that we thought might justify it because it wasn't stated on the record by the people, the record is insufficient.
That's correct, and that's what the court held in People versus Leota, is that if the people do not state on the record, even after their statement of readiness, that they are chargeable with the entire adjournment that they requested, yes.
What about the fact that during the same specific time period, the court wasn't available? Judge
Yes.
Egan was in special term, which there's no time to run a trial at that point in time. And also, she was down in Chautauqua running a trial at that time, so the inability, unavailability of the court.
Yes,
Should
and
that
the
be-
trial,
Shouldn't they be taken into consideration?
yeah, the trial court cited Wallander and noted that the special term should be considered court congestion. The people were no longer ready for trial when they weren't ready for their pretrial Huntley hearing, and they never restated their readiness during the prolonged adjournment.
Wasn't that adjournment also something that was requested off the record, obviously? And my recollection is correct, the defendant never consented to that, is that right?
Yeah, there was no consent to the adjournment, and it was requested through text message off the record, which goes back to the point that they were required to state it on the record.
So is that why you're saying then that the court's unavailability is not something that should be considered at this time?
No, at the court congestion, either they were, A, not ready, and in addition, like the main issue is that they did not state the reason for the adjournment on the record as they were required to do.
Anything further, counsel?
Nope, nothing further.
Thank you.
I have the rest of my brief. Thank you.
May it please the court, Michael Hillary for the people. I'll begin by acknowledging that there is a lack of a conclusive demonstration of the reason for the adjournment here on this record. I would note, however, that the record does give excellent warrant to believe that the reason for the adjournment had to do not with the pending charge, but with two charges that had been dismissed that the people were looking to re-indict. Defendant, in fact, acknowledges that in motion practice in papers that are a part of that record. Now, there's nothing in the record to suggest that the people became unready. They did declare ready twice before this particular adjournment, and the declaration of readiness is deemed to be accurate and truthful.
And this is the same adjournment that we're talking about that was not on the record? That
Yes,
was
Your Honor.
Maybe
the
consented between
89
the parties?
total days. And as Your Honor pointed out,
And the defendant never consented to that, correct?
the consent is really an okay in a text message, which is admittedly vague, and I wouldn't rely on that in the argument. What I am relying on is that there's not only no indication in the record that the people became unready, but there is every reason to believe that they remain ready and that the reason for the adjournment had to do with indicting two formerly dismissed charges, which became a part of the plea negotiation later on.
So there was a reason, but it just wasn't on the record. It wasn't made plain in these pages that we read.
It was not made plain, not as plain as it should be. What I'm essentially asking the court to consider is the record as a whole and the fact that the record suggests that the people never became unready. And that's what would allow application of, for instance, or rather distinguish the case of Betancourt, where there is a momentary unreadiness that now the people are facing, which is not the case here.
So when you ask for an adjournment, that's not some signal that you're unready to proceed?
Well, it isn't necessarily a signal that we're not ready to proceed on the pending charge. As indicated again on this record, to a high probability, the people are asking for the opportunity to represent additional charges. I would analogize this to perhaps the Miller case, the Third Department case, which is cited in the brief, where the court said that just the request of an adjournment alone does not render the people unready. In fact, the people could request a superseding indictment, a period of time within which to bring a superseding indictment. And
But that wasn't done here.
No, I would say this is analogous in the sense that we are looking to re-indict formerly dismissed charges. Unfortunately, the record is, as Your Honors have indicated, it is not as clear as it should be. And I'll ask the court to consider the record.
We'll take a look at that, counsel. Thank you.
Thank you.
Case 140, People versus Abraham.
Good morning, Your Honors. May it please the Court. Clea Weiss on behalf of Ted Abraham. A trial court has a constitutional duty to ensure that a defendant, before he pleads guilty, has a full understanding of what his plea connotes and what the direct consequences of that plea are.
Well, the issue we're dealing with here is the fact that the fine is a direct consequence of the plea,
That's correct.
as opposed to a collateral, which we address in some cases,
That's correct.
but it's not here. And your argument is that the plea becomes per se invalid.
It's per se invalid, and I think one of the specific contested issue here is preservation. The people submit that Mr. Abraham failed to preserve his contention, but this case falls squarely under People versus Lowry or Laurie from the Court of Appeals, where when the first time you learn of a direct consequence is when it is imposed upon you, not purely at sentencing in this case, but when sentence is actually imposed and he's told he will have to pay a $3,000 fine. That is the context where preservation is not required. And as Lowry notes, that's because there's not even a procedural vehicle to move to withdraw your plea at that point. CPL 22060 subsection 3 is only available before the imposition of sentence. And in this case, where the $3,000 fine is imposed, on the second to last page of sentencing, when it's actually imposed upon him after the incarceration is imposed as well. So at that juncture, Mr. Abraham does not even have a procedural vehicle by which to move to withdraw his plea, and that's why preservation is not required in this case.
And counsel, your alternative argument is just to strike the fine, but that's not a remedy that's available to your client, is it?
It's not. The proper remedy here is vacator of the plea.
And go back to pre-plea status.
That's correct, and it's just what due process requires, because where a plea where you waive your right to trial and you waive your right to not incriminate yourself, those are sort of the most important rights we have in the criminal justice system, and you need to know what you're giving up when you do that. So vacator of the plea is required in this case. We do, if this court disagreed with us, we do ask for the fee to be, or the fine to be vacated in the interest of justice under this court's power to modify sentences, but we do think that vacating the plea is the proper remedy.
Thank you, counsel.
Thank you.
Good morning, Amy Wallensack on behalf of the people. It's our position that preservation was required in this situation and that this case falls under the Court of Appeals decision in People v. Williams. An important distinction that I'd like to focus on is that this was not a simple plea proceeding followed directly by a sentencing proceeding. This defendant pleaded guilty to be placed on interim probation, and there were 4 court appearances after he pled guilty and before sentencing at which he could have sought further clarification about what exactly was allowable by law.
Counsel, it wasn't his responsibility to ask, right? The responsibility is on the court to inform him of the consequences of the plea.
Yes, and the court at the time that he entered the plea told him that if he did not successfully, there was a promise if he successfully completed interim probation, and if he did not successfully complete interim probation, he could be sentenced to anything allowable by law. And he had 4 court appearances at which to explore further and seek clarification on what was allowable by law, but he did not do so. And unless there are any further questions, I'll rely on our papers.
No questions, counsel. Thank you. Case 144 in the matter of Albina H.
Your Honor, we have Catherine Sullivan. She's just taking a moment to come over.
Very good, thank you.
Your Honor, she seems to be having a technical difficulty. We can work
Well-
with her.
We're going to recall this case. We'll recall 144. Thank you. Case 145 in the matter of Dorica S. Counsel, if we'll hold up just 1 second, we've got to make sure everybody's on the video screen here.
Okay.
You look raring to go, so I like that. So let me make sure everybody can hear us. Counsel Lorenz, can you hear us?
Yes, Judge, can you hear me?
And we can hear you, Counsel Fox?
Yes, Your Honor.
And Counsel, is it Mannion?
Yes, Your Honor, and I can hear you loud and clear. Thank you.
Very good. Thank you, Counsel. I think everybody's present. Please proceed, Counsel.
Thank you, Your Honor. I'm Charles Greenberg, representing Leopold G. in the in his appeal from the determination that he abused or deliberately abused the 5 children of the 4 children involved in this case. This court does have me at a certain advantage because last December they had already, you had already ruled on the mother's case, that the mother was liable for the abuse or the derivative abuse, even though she personally had not, just by simply failing to protect the children. So my role is, and when I read David Pajak's brief on behalf of the mother, he did not exactly state that my client abused the children, but he only took that position simply as a point, as a given, just simply to defend his client. My client does take the position that he did not abuse any of the children. He certainly did not abuse Dorica. The allegation was of sexually abusing her. But I also point out
Your client didn't testify, right?
I'm sorry?
Your client didn't testify, right?
That is correct. My client did not testify, and that, of course...
So he could have testified to what the representation you just made to the court.
That would be correct.
Okay, go ahead.
Okay. But I do point out that even if you decide to give him, to draw the negative inference for him not testifying, Your Honor, we still have the issue that Dorica's statements were not properly corroborated. 1046 AVI, you can certainly bring in experts and the forensic interviewers to come in and say, well, this is what you told me, but where was the corroborating evidence for that?
Well, there was a medical record that indicated that she had been raped.
Well,
there was her testimony and the confirmation of the lotion bottle, and in addition, the caseworker testimony.
Well, the case only repeats what she told her, but the lotion bottle doesn't mean that proves that Mr.
She said he used lotion, and I can tell you where it is. The caseworker that afternoon sees the lotion bottle exactly where she says it's going to be.
But that doesn't necessarily prove the veracity of what
But it's corroborating.
Okay.
The level that we're looking for in corroboration, it's some proof to support, right?
It's as long as you just get it over the finish line, yes.
Yeah, and we also have, in addition to what Justice Del Conte just mentioned, we also have a victim who's using, I think, age-inappropriate knowledge of sexual matters.
Yes, yes.
Which I found interesting proof of cooperation.
But nobody ever asked her where did she learn this language, though. So that's what I mentioned in my own brief as a rebuttal to that point, is that was it ever corroborated as to where did she learn that kind of language? Nobody ever asked the caseworker, how did she follow up with, well, how did you learn that language? So.
Okay, we'll take a look at that, Counsel.
Okay, any other questions, Your Honors?
No other questions, thank you, Counsel.
Okay.
Hold on, we don't have you here. Who's up next? Is it Ms. Lorenz? Let me take a look at it.
I think it's Mr. Mannion.
It is not Ms. Lorenz, yeah, Mr. Mannion, yeah, thank you. Mr. Mannion?
Thank you, Your Honor. On behalf of the Erie County Department of Social Services, thank you,
Yep.
Mr. Mannion.
Proceed, yep.
Thank you, Your Honor. Your Honor, I Unless the court has any questions at this time, I would just ask this court to affirm the decision of the trial to its abuse and derivative abuse finding of the children. In this case, as the court has already pointed out, there was more than sufficient evidence to demonstrate that.
Well, I don't know if we were pointing it out, we were asking questions, but I assume that you made those arguments in your brief, though. We recognize that.
I did, Your Honor, and unless the court has any questions, the department will rest on.
Very good. Thank you. And now we have confidential counsel. Please proceed.
Thank you, Your Honor. Russell Foxford, Legal Aid Bureau, representing the child Dorica S. Dorica was 9 years old at the time this happened. As Your Honor pointed out, there was inappropriate knowledge. There was telling detail in the disclosure. As Justice Del Conte mentioned, there's physical evidence corroborating this. There's a medical examination. There's really an unusual amount of corroboration for this kind of case. Otherwise, we would rest on our papers and entertain any questions by the court. Thank you.
No questions. Counsel Lorenz, do you want to be heard?
Just briefly, Judge, Jennifer Lorenz, on behalf of the children, Jibu and Salama, as the court and counsel have already indicated, there's ample corroborating evidence here, and unless the court has questions, I will rest on my brief.
No questions. Counsel, Mr. Meldam.
Thank you.
Please, the court. Gary Muldoon on behalf of Luna Zero. The child is 4 years old. In my brief, I had noted that the child is 3 years old. The child has turned 4. I submit that there is ample corroboration in this case, and that the corroboration requirement, which is lower than the corroboration requirement required in criminal law, is amply shown both by the child's knowledge, the child's use of inappropriate language, the lotion that was found, and most tellingly, by the medical examination. So I submit that there is ample and that there is a sound and substantial basis for the court to have made its finding.
Thank you, counsel.
Thank you.
Case 147, Autry versus Garcia.
Your Honor, we have whenever you're ready, Ms. Sullivan for 144.
We'll call that case next. Case 147.
Hello, Your Honor.
Mr. Walsh, we're just waiting for your opponent, who it seems is also appearing by video conference. So one moment, please.
Thank you.
Mr. Williams, can you hear us?
I can, Judge.
Very good. Mr. Walsh has also indicated he's online, and we can hear him, and he can hear us. So please proceed, counsel.
Thank you, Your Honors. May it please the court. I don't usually do this, but I'm starting at page 10 of the respondent's brief. They say, and referring to People ex rel. Fast versus Molina, which I cited to bring on this the second department decision. They say, regarding step 1, the People's Declaration of Readiness occurred more than 90 days after the commencement of his confinement on the Cheektowaga charges. There's no dispute about that. What happened here was, by delaying the case and then blending 3 cases into one in the indictment, the people were bound by 3032A because the first charge in Cheektowaga.
Mr. Walsh, I'm going to hold you up just for a second, and I'm going to ask our tech people, have we lost Mr. Williams? He doesn't appear on this. There he is. Mr. Williams, have you been with us the whole time?
I went out about 10 seconds ago, and then it said to retry, rejoin, and I did.
Okay, very good.
My opponent saying that he was starting at page 10 of my argument.
Mr. Walsh, if you don't mind, could you resume from there?
Sure. So, based on the concession that more than 90 days have elapsed under the statute, I don't really think there's an issue here to even get into the other issues that I've raised in the brief, both the post-indictment delay regarding discovery, regarding the tooth, and the camera. So we believe, because the case was indicted in the grand jury came back in late April and he was arraigned in May of 2022. There's no question that the 90 days elapsed, and therefore he was entitled to bail. The two impediments that the people bring up are, A, there was this contempt charge that was filed December 9th, and there was bail placed on that. Okay, it was still more than 90 days after that case started. And then they refer to the parole detainer, but in the argument, actually before Justice Hendage's, they sort of conceded that really wasn't a problem. But to the extent the court thought it was a problem, by the time Mr. Greenman had made this motion and argued it, we had obtained a writ of habeas corpus to eliminate that parole detainer. So we think there's no basis at all for continuously detaining my client. He's been in custody for 25 months since being charged in this case, and there's still no trial date. I was getting a little concerned. I tried to move this up like a motion because the court, the Chockwin case says that if you don't get this argued and considered before trial, it becomes moot. So I apologize for my motions and some of the procedural stuff that got me here.
No, we understand, counsel. So that was going to be one of my questions: is he still currently detained? And you're indicating to me that he is.
Yes.
And there's not a trial date.
Yeah, they possibly in September.
Okay, very good. Thank you. That's helpful. Anything further, counsel?
No, thank you.
Mr. Williams.
Judge, I argued in my brief what was argued below, and I believe that the court's decision below is supported by the record. First, I argued that this issue appears to be moot. The prosecutor's responding affidavit said that the defendant, the petitioner, had been granted release on January 4th of 2022 on the charges that are...
Those are the Cheektowaga charges, Mr. Williams?
Yes, Judge.
Okay, very good.
So he was granted release on those Cheektowaga charges as per the prosecutor's responding affidavit on January 4th, 2022, which was about a month after he'd been charged on those charges and well before this motion was made by Mr. Greenman. The court agreed or seemed to agree on this record with what the prosecutor said because it stated that it had released the defendant 18080 on the cases that were divested to the court at that time. The people also argued below, first I'd like to say defendant's motion below was made pursuant to CPL 3030 subdivision 2A. And in essence, it says that if the defendant is in custody, the people must be ready for trial within 90 days of the commencement of the criminal case. Backing up a step, because the defendant was released, there was no bail on him, and this really wasn't an issue. But nevertheless, the people went on to address why, if the defendant was still being held on those Cheektowaga charges, his being held would have been appropriate. People relied on 3033 CII, which says no release where the defendant is held on another charge. The people argued in the court below, and the court accepted it, specifically found that the defendant had been held on 36 counts of criminal contempt, which were subsequently converted into count 4 of the indictment the whole time period. So since the defendant was properly being held on other charges, this motion was subject to denial by Judge Hendages. The people also relied on CPL 3033 CIII, which in essence states that where the defendant is released from custody and then charged with another crime, he can be held. So the people argued that counts 1 and 2 of the indictment were a separate incident from the Cheektowaga charges, which are at issue here in this appeal, and that count 1 specifically permitted remand, which was granted by the court. The court agreed with what the people alleged and said that the defendant was indicted on a charge that wasn't even pending at the time of the Cheektowaga charges. I would assert that the case relied upon by the petitioner, this People ex rel Fast versus Molina, doesn't apply. That case involved a prosecutor office that was relying on CPL 30.30 subdivision 4 time exclusions to extend the 90-day period. The people were not relying on those time exclusions at all. We were relying upon 3033C. Nevertheless, even if it applied, the people argued about the 2 points that defendant specifically raised below. The defendant complained below that there was video from 999 Arrow Drive, which is Pharaoh's of all places. The people allege that they went to get it approximately 2.5, 3 weeks after the event, and that it was already gone. We argued that we were diligent, and the court agreed. The defendant also complained that there were dental records that should have been turned over. The people argued that those records were only obtainable by subpoena by the people, and that legally defendant could also obtain them by subpoena, which in fact he did in this case. And the court agreed with the people's argument. Defendant finally argued that those were Brady material. The people respond now that they were not Brady material. They were not suppressed because the defendant was aware of them and got them himself. Unless there are any questions, I have nothing further to add.
No questions, counsel. Thank you.
Thank you, Judge.
Thank you.
Recalling case 144 in the matter of Albina H. Counsel Sullivan, can you hear us? We can't hear you. We still can't hear you. My suggestion is going to be to call back with our IT department, and we'll hook you up with a phone, and then we'll hear from you. Recall the case once again and hear from you then. Okay? So call back and we'll do a phone connection. Thank you. Case 148, Bird versus Target. Is it, counsel, forgive me for a mispronunciation, is it Frisia?
It's Frisha, Your Honor. Thank you.
Okay, counsel, we can hear you. Can you hear us? I assume you can?
Yes, loud and clear.
Very good. Let's proceed.
Okay, thank you, Your Honor. Good morning, Your Honors, and may it please the court. Motion court erred in granting defendant's summary judgment motion because triable issues of fact exist within their own moving papers as to the existence of the hazardous condition. It is well settled that a wet condition, especially after an area has been mopped, is a defective condition which will result in liability. And I cite the case Eleanor v. Caleda Health, 155 AD 3rd, 1576, in support of that. Here, defendant annexed the conflicting testimonies of plaintiff and its witness, Ms. Ferrari, in their moving papers. Plaintiff testified specifically that the floor was shiny, glossy, and had a medicinal stench to it at the time of the fall. Plaintiff also testified that after the fall, her clothes were wet. And you can find that in the record at 194 to 195. Additionally, defendants annexed the guest incident report at page 402 of the record and the LOD investigation report, page 404 of the record, both of which indicate that the floor was not clear and free of debris.
Is that the form where there was a box that needed to be checked and it wasn't checked?
Actually, I think the box was checked and it said, was the area clean, dry, and free of debris? This is at page 402 of the record.
Right.
And it was checked, no. However, defendant's witness testified that small droplets of water caused the plaintiff's injury. However, to the extent that our witness was plaintiff was questioned as to the small droplets of water theory, and she specifically disagreed with that. And that's at page 205 of the record. The question was, is there anything in the report you disagree with? Yes. What? Where Miss Ferrari wrote droplets of water. I never told her that they were droplets of water. I said there's something on the floor in the bathroom. So there is an existence of a triable issue of fact as to the hazardous condition, which is circumstantially that the floor was mopped, water was left there, and that plaintiff fell. Additionally, defendant's only Fourth Department case that he cites, Keller v. Keller, to say that the use was incidental to the bathroom. In that case, the plaintiff slipped and fell in a private bathroom after she opened the shower curtain and while in the middle of taking a shower, reached to retrieve a brush and hurt herself. There was no showers in the public bathroom at Target here. and the case is completely inapposite. So on this point, tribal issues of fact exist within defendant's own papers, and as such, they failed to meet their prima facie burden. In any event, defendant did not establish the issue of constructive notice and did not establish the prima facie burden as such because they did not submit evidence concerning when the area was last cleaned or inspected prior to the accident, which is a requirement for a summary judgment move-in. In fact, the witness testified specifically that she did not have any independent recollection as to when the area was last inspected. You can find that on the record at page 298 to 312, the line of questioning there. And on this issue, defendant's prima facie burden was not met as to notice. And the case I'll cite is Andrews v. JCP, 208 AD 3rd, 1607.
Go ahead.
Yes.
Counsel, I guess what I want to ask is that the defendant says that they came to the bathroom 5 minutes later and found it to be clean, dry, and free of debris, and the only thing they found was 3 little droplets of water. We're going to hear defendant tell us that in a minute or two. Are you saying that that is not enough to carry the day?
Yes, because the defendant's burden is to eliminate all tribal issues of fact. And to the extent that she disagrees or presents a conflicting testimony with my witness, that just demonstrates the existence of tribal issues of fact, which should be sent to a jury.
Okay, thank you.
Counsel, do you want to address the Highlands liability in this case from your perspective?
Yes, Your Honor. So defendant Highland did not meet its prima facie burden in demonstrating that it was an out-of-possession landlord because it did not submit a properly authenticated copy of the lease.
We have an employee, Ferrari. I want you to address this. Ferrari, who's a supervisor, who seems to testify or testifies that Target had the sole responsibility and control of the bathroom area and the interior of this building, and not Highland. And why is that not relevant testimony concerning the relationship between Highland and Target?
Well, it might be relevant to the issue, but in order to establish the prima facie burden, defendant Highland was required to submit the properly authenticated copy of the lease with its moving papers. And I'll cite the case Smith v. Marshall Farms Group Limited, 218 AD 3rd, 1322. That was a 4th Department case, 2023. And basically, without that properly authenticated copy of the lease, they cannot meet their prima facie burden despite the testimony. And even still, if you look at page 289 of the record, Ms. Ferrari testified that she did not have any personal knowledge as to the lease agreement. And she was never shown a copy of the lease agreement at her deposition. And on that point, a case I have here, Dorset v. 285 Madison Owner LLC, 214 83rd 402. The case, the court in that case ruled that the defendant did not meet its prima facie burden in establishing, as a matter of law, that it was an out-of-possession landlord because the lease wasn't properly authenticated with the papers.
I think we have that argument, counsel. Anything further?
That's it. Thank you, Your Honor.
Thank you, counsel.
May it please the court. Good morning, Your Honors. My name is Jody Brianti with Hurwitz Fine on behalf of the defendants. I'm going to just jump in and address a few things that my opponent said. He said that, number one, that we did not meet our burden of proof. We did not establish a prima facie case entitling the defendants to summary judgment. We did submit photographic evidence. We submitted sworn testimony establishing what the condition was of the bathroom within 5 minutes of the fall. I would submit that we did meet our burden of proof. The argument before the court is that there is no dangerous condition, that the evidence in the record demonstrates a lack of a dangerous or defective condition.
But let me ask you this, counsel. If the evidence in the record demonstrates, let's say we agree with you that the evidence demonstrates a lack of a dangerous condition 5 minutes afterwards, but we have testimony from the plaintiff concerning the condition of the floor at the time of the fall, doesn't that raise a question of fact?
Well, we don't actually have testimony from the plaintiff about the floor. She testified that she did not observe any water or liquid on the floor ever. Not before her fall.
Was there some testimony, you can correct me, you know the record
Sure,
better than I do.
absolutely, Judge.
Was there some testimony that there was dampness on her clothing after she fell?
There was, but no connection.
Isn't that some indication or testimony relative to where that she fell and now all of a sudden her clothing is damp, or wet? Isn't that some evidence that wetness
Could be
came from the
also
floor?
evidence that she got wet washing her hands or when she was using the toilet. There's no nexus that was provided, no explanation provided that that came from the floor, particularly in light of the fact that she never felt water on the floor. She never saw it, not before and not after. And as far as the claim that there is a question of fact regarding testimony of small droplets of water on the floor, let's put what the plaintiff said aside at her deposition. We only have one witness who saw the floor. The plaintiff didn't. The only thing the plaintiff talks about is a medicinal smell. She talks about the floor looking shiny, but there's no follow-through there. I heard my opponent use the word mop. I would challenge the court to find the word mop anywhere in the record. There is no testimony whatsoever, no proof that this floor was mopped, that there was a cleaner inside, that there was a bottle of cleaning solution. Zero. You know, we often see when we're reading briefs that, you know, speculation, surmise, and conjecture, insufficient to establish summary judgment or to meet one's burden of proof. I would submit that all that we have here from the plaintiff is speculation and conjecture. Absolutely no nexus tying together her words to the existence of a dangerous condition.
You carried your burden, it shifted to the plaintiff, and all you have is conjecture, essentially, on their part. That's your argument.
Because we submitted sworn testimony from a witness and photographic evidence, and really nothing contrary from the plaintiff on that
When we're
point.
talking about conjecture, didn't you say, well, maybe her clothes got wet from washing her hands or something like that? I mean, aren't we dealing with conjecture now all along? Aren't you dealing with conjecture now too?
I think what we have to focus on is what the proof is. And so the proof in the record is what the eyewitness saw and what the eyewitness photographed.
The floor had a medicinal scent to it, shiny, glossy, and what other words did she use? Her clothes were wet. I mean, now you're saying, well, there's three small droplets.
I'm not saying it, Judge. The pictures, I think the pictures speak for
That's what
themselves.
your manager said basically
Yeah.
a picture with 3 small droplets of water.
She testified to what she saw, and then she took photographs, and we submitted those
And you
photographs.
submitted the incident report, which showed or demonstrated what the injured party indicated.
Yes.
Do you want to address the Highland lease and the authentication issue?
I think the Highland lease is a bit of a red herring here in the case. If the court determines and agrees that there's no dangerous condition, then we never get to Highland. In order to keep Highland in, my opponent needs the lease. So I find it a little ironic that he's making the argument that we can't use the lease to demonstrate what their responsibility was with respect to the property.
Well, the issue that he's raising, I think, is it wasn't submitted in evidentiary form, right? Would you agree that that's true?
I would agree that that is true. I would also submit that we have a witness, again, who testified that it was Target's sole responsibility to repair and maintain that bathroom during business hours. And
Didn't
that,
the lease indicate what the responsibilities were between those parties? And didn't that witness testify that she really didn't ever see the lease and didn't know what was contained in the lease?
there can be more than one form of admissible evidence, Judge, and I would submit that we did submit admissible evidence demonstrating who was responsible for the bathroom.
What seems as though, for summary judgment purposes, it's not authenticated, you admitted that.
That is correct.
Maybe it'll carry the day at trial.
I think we did submit admissible evidence. I'm acknowledging the lease issue.
You have a witness that couldn't testify. The witness didn't know the terms of the lease, never saw the lease.
What the witness can testify to is the duties and responsibilities of
And
the
again,
parties, because she was the
There may have been
manager.
some other condition on there as well in the lease that she wasn't able to testify to. And maybe a trial sheet, you'd have the opportunity with the
I would just,
properly authenticated,
understood,
admitted.
yeah. I would just circle back to what we're talking about here, which is a transient condition of liquid on the floor. That's what is pled in the bill of particulars. The manager has said that is Target's sole responsibility to address and deal with during the course of the business day.
And your argument is if you win there, it doesn't matter what happens with the other issue?
If the court is convinced that there is no dangerous condition, then you never get to Highland. In the issue of constructive notice, we did not move on constructive notice because our sole argument is that there is no evidence of a dangerous condition.
Very good. Counsel, thank you.
Thank you very much.
Are we ready to recall case 144 and Counsel Sullivan?
We have her on the list. We're going to give it a shot, Judge.
All right, very good.
She should be ready, audio only.
Very good. Counsel Sullivan, are you there?
Yes, Judge. Can you
Okay,
hear me?
we can hear you. Can you hear us?
Awesome. I can hear you. Thank you.
Very-
Sorry
very-
for the confusion.
Not a problem. With these audio connections, I want you to kind of pause a little bit because if there's questions, you need to be able to hear us, and if you're talking, you won't hear us. So just kind of be aware of that. Please proceed with your argument, counsel.
Understood. Thank you. May it please the court, Catherine Sullivan, attorney for the children, Albina and Isaiah. I was anticipating Ms. Walsh to be present to argue, but as everybody else is submitting, I guess I would just rest on my brief unless there's questions.
Okay, counsel, just so I'm clear, and I do have a question of you now that you're here with us. Is part of your argument that we're missing records, including I think it's the Helio health records, the Huntington records, the caseworkers' notes, the Vera House records, and that without those records, we have an insufficient record upon which to properly review this case?
That is absolutely my position, that the appendix method was improperly followed, and the court does not have enough information to determine whether there's a sufficiency of, evidence to support the conclusions made by the court, so that the appendix method is really inappropriate under these circumstances.
And all the records that I've mentioned were records that were marked and moved into evidence at the hearing below, is that correct?
Yeah.
Okay, very good.
I wasn't part of the proceedings, but according to the transcripts, they were all received.
Very good. Counsel, I have no further questions. No further questions. Thank you, counsel.
You're welcome. Thank you. Bye-bye.
Case 149, Hamill versus Lazor. Counsel, proceed.
Thank you, Judge. Matthew O'Neill of Costello, Cooney & Fearon on behalf of the appellants. May it please the court. Supreme Court's denial of injunctive relief was an error and should be reversed for three principal reasons. First, the Supreme Court erred in holding that plaintiffs could only enforce setbacks to a lot line that adjoined their line. Second, the Supreme Court erred in finding that a two-story, 3,200 square foot structure qualified as a garage for no more than 3 cars, as that term was used in the protective covenants. And lastly, the Supreme Court misapplied this court's holding in Clice v. Stein.
Counsel, let me ask you a question with respect to the garage. Did the restrictive covenant specifically set forth the requirements for size for the garage? Or did it just say it couldn't be used for residential purposes and it had to be used for 3 cars?
Judge Ogden, the covenant says that it has to be for residential purposes and for no more than 3 cars.
But it cannot be, it says it cannot be it can't be used as a residence. The garage cannot be used as a residence. Didn't it say just as a shed or for cars not more than 3?
There are 2 permitted outbuildings within the subdivision. The first is a shed, which would be a structure, I think in common parlance, used purely for storage, and then for a garage for not more than 3 cars. And I think that term needs to be read in its totality, which is that it is a garage for the purpose of storing not more than 3 cars. And I will be candid, in my review of New York case law, I did not find a case hammering what is and is not a garage as it's specifically used within protective covenants. I'll also be candid that it is true that under New York law, that where a term is ambiguous, that term should be read in favor of not restricting the use of land. However, I submit that a garage for not more than 3 cars is not ambiguous in putting no size restriction on all, as the court below did, kind of reads the word garage as it's commonly used in a common sense manner into oblivion. And if we look at cases that have interpreted the word garage and protective covenants elsewhere around the country, you find that there is a common sense, and the term, this is from an Illinois case known as Vandalo, that there's a common sense interpretation. In that case, where there was a large building that had recreation space planned within it, not a garage. In the Kentucky Sims case, we had an oversized structure that was intended to use a multitude of various recreational vehicles, was determined to not be a garage. And the Roberts case in Indiana was, I think this one is similar to our case because it had language of not more than 2 cars. And the Indiana court held that that space beyond that use was prohibited.
Counsel, you're asking us to say, looking at the language here, no more than 3 cars has to mean something in terms of limitation in size. And we need to read that into the language even though it's not there to practically and in commonplace interpretation make it mean something. Is that essentially what you're saying?
That's essentially what we're saying. And if we look at the record at the trial, this is a structure that is 3,200 square feet, has a large second story, is plumbing capable, and also it is hundreds of feet away from the house. And I think we take these factors together, it is not a garage as applying a common sense interpretation.
So counsel, your point is that there may be a technical violation, but isn't what the court really said here is he has to balance the equities, and the equities don't favor your client here.
So, and this brings me to my second point, Judge Del Conte, which is the application of Kleist versus Stein. And in that case, I think several points. Similar to Kleist versus Stein, I should note that this was a knowing violation. I think it's worth pointing out that the plaintiffs, first of all, the record at the trial was that the respondents were aware of the protective covenants from the very beginning, from the closing, is what the testimony bore out. And further, they're aware of the plaintiff's opposition to the construction and their specific objections from, practically the breaking ground. One key difference, I think, from Kleist is the Kleist was solely a setback case. It didn't handle the overall residential character type covenants that is expressly built into the whereas clauses of the protective covenants here.
But how do you get from there, assuming arguendo that your argument is correct, how do you get to the balance of the equities?
Judge, again, courts have broadly enforced residential character and subdivision character restrictions in New York cases. That was not presented in Kleist, so I submit that specifically with the garage factor and whether this is a conforming type of building, Kleist is not applicable. And further, I think the balance of the equities, we have to look at the fact that this was a knowing violation. Otherwise, the rule, of course, is when you're presented with protective covenants would be to force ahead in light of the covenants, in light of pending litigation, and I use the language in our brief of proceeding at their risk. If defendants are permitted to proceed regardless of the circumstance, they're not even operating the risk. They're being rewarded for their doggedness in pursuing the construction project which is in violation of the structure. Circling back to the first point of that of standing, in these protective covenants, the clear language is that the drafters intended maximum enforcement standing on behalf of the residents. You know, the covenants state in the first page, in the event of a violation or attempted violation of any of the covenants or restrictions herein, it shall be lawful for any person or persons to bring an action, law or equity. So given this language, use of the word any, both in qualifying the nature of the objection and who may bring a lawsuit, I submit that the court's finding in favor of the respondents that the setbacks were not specifically to the lot lines that adjoin the petitioner, or excuse me, the plaintiff's property was an error. Even if you don't consider the fact that there's under New York law, it's not specifically required for a setback to be enforced by an adjoining lot in terms of the specific lot line, but a resident in the, the proximate area. And plaintiffs here were in the immediate proximity because they were adjoining a separate line, the back lot, not the side lot. And the result of the encroachment to the side lot lines was that the non-conforming structures were markedly closer to the plaintiff's house than they would have otherwise have been. And
Counsel, we'll take a look at that.
Yeah, thank you. And of course, no other questions, I rest on my papers. Thank you.
May it please the court, John Coughlin, Smith, Sovic, Kendrick, and Sugden on behalf of the respondents. Initially addressing my colleague's point regarding the language of the restrictive covenants, there is no language regarding the size of the garage. The plaintiff's argument is primarily based on their beliefs and hopes and conflating that with a definition of the size of the garage in the restrictive covenant.
Counsel, can we agree that without necessarily crediting your opponent's argument, can we agree that a common three-car garage would not require the kind of square footage that's involved in this particular building that we're dealing with here?
I wouldn't disagree with that, Your Honor.
But you're saying, so what? Essentially, that's not what we should be looking at.
Correct. And I think if you look at the law in New York in terms of interpreting restrictive covenants, the courts are going to take a narrow view of those with the expectation that a property owner is going to be able to have a unencumbered use of the property. So in terms of the garage itself, all it says is that the garage can only be of a size of not more than 3 cars. There's no limitation on size, there's no limitation on height. None of that language is included. If the individual that initially drafted the restrictive covenants wanted to include that in the covenant, they certainly could have. Similarly, as it pertains to the argument regarding the side lot lines, the restrictive covenants are also silent as to the effect of a property owner who has purchased continuous parcels, as we have here. And in that regard, the Kleist case...
Does that get to the argument that this was a knowing violation? I think there's some evidence in the record that your client had the 3 lots, which were next to each other, and that there was an understanding that because of that setback requirement wasn't going to be something they need to be concerned about? Is that fair?
I don't know if that's exactly correct, Judge. I think if you look at when they purchased the property, the initial request was that they were going to agree not to do any building on Lot 6, the middle lot, and that was at the request of the appellants and the buyer or the seller of their home. And the respondents agreed to that request with no consideration. There was no reduction in price. They agreed to purchase that lot and not build on it to accommodate the appellant's request. In terms of a knowing violation, I think initially the respondents believed that, well, we've purchased these 3 parcels. We do have an ability to build on those parcels and develop them as we see fit. Obviously, the issue arose regarding the appellant's contention that the construction was in violation of the side lot lines. But to get to I think the crux of the case, which many of you have touched on, if we're getting to the balance of the equities, frankly, that simply favors the respondents in this case. The only harm that the appellants have asserted is that their view is somehow impeded by the construction. And in the trial record, there was simply a lack of any sort of evidence, be it photographic, that their view is actually obstructed. The pictures that are in the record show that while the respondent's construction is visible, it is not obstructing the appellant's views of the surrounding property. And so if we're balancing the equities, we're looking at a view of the appellants who now see a house when they look out from their deck versus the owners of these 3 parcels who are attempting to develop these properties to build what they termed their dream retirement home and have invested a substantial amount of money in that construction. And frankly, if we're balancing that, it weighs in favor of the respondents. So for those reasons, in addition to the just complete lack of evidence in our position at the trial level showing violations or irreparable harm, we do believe that the trial court's decision was correct and it should be affirmed. And if you have no further questions, I'll rest.
No questions, counsel. Thank you.
Thank you.
Case 150, Meldam versus Holiday Meadows LLC. Justice Montour is recused on this case. Counsel Zelinski, can you hear us?
I can, Your Honor. Thank you.
And we can hear you. Please proceed.
May it please the court. Good morning, Your Honors. Richard Zielinski on behalf of the appellants here. The issue on appeal here is whether the height differential between 2 surfaces standing alone is sufficient to constitute a hazardous defect. And these are 2 surfaces that are different in character, one being parking lot for walking and parking vehicles, the other being an unimproved grassy area, not designated for walking. There's no claim here that the parking lot was crumbling, cracking, slippery, there's no loose pavement. The claim is simply that in walking from grass to the parking lot, the plaintiff fell and blames the height difference.
Counsel?
Yes.
The plaintiff says something else. They say there's a height differential, but that height differential was blocked, was obscured because the grass was so high. You couldn't see the differential. That's why, in their mind, it's defective and dangerous.
Certainly, Your Honor. Plaintiff's counsel has said that. Plaintiff
Yeah, but
did not.
and the property manager said that, yeah, it needed to be cut. It was supposed to be cut the next day or so.
Ms. DeLuga, the property manager, testified that the lawn was cut weekly, so every 7 days. And at the time of plaintiff's incident, the lawn may have required it within the next 2 days. It's unclear specifically how long it had been since it was last cut, but more specifically, the plaintiff herself never testified that grass was an issue, never testified that her view of the parking lot was obscured. In fact, she questioned herself during her testimony at page 54 of the record. Did I notice the difference between the grass and the parking lot? Yes. She never brought up this issue with respect to grass. She never claimed it was hidden or that it was a trap. And again, that was not pleaded in the complaint. It was not pleaded in the bill of particulars. Any suggestion that the grass was too high on the date of the incident comes solely from plaintiff's counsel's leading questions to the plaintiff's daughter, who was, testified much later after the fact and was essentially fed language.
Let me ask you this, counsel, and you know the record better than I do, but was plaintiff's daughter was, the plaintiff was visiting with the daughter prior to the fall, and I think plaintiff's daughter emerged from her apartment once she learned that her mother had fallen and was there and was able to view the condition of the grass and the pavement. Is that fair?
That is fair, Your Honor. Okay. However, I will note that even had the grass been too high, even if the grass was higher than the height differential and it did obscure that, it didn't cause or contribute to this incident. The plaintiff testified about this incident twice, once during this lawsuit and once during her subsequent lawsuit involving a motor vehicle incident she was involved in a few months later. And both times she said she simply failed to make that step from the grass onto the pavement. She had never testified in either of the lawsuits that she couldn't see the height differential, or that she didn't know it was there, or that
Well,
it even
counsel,
caused or contributed.
Wasn't it more than just a height differential? Wasn't it the lip of the blacktop? Wasn't that what created the hazardous condition? And the grass was what prevented her from being able to see it.
This is all speculative arguments brought up after the fact and in response to this summary judgment motion. The plaintiff said, yes, she caught her foot on the lip of the pavement. So that is the fact that it is higher up off the ground. She's claiming that pavement's higher than the grass, therefore she tripped.
But your argument, counsel, if I understand correctly, your argument is plaintiff, the party in this case, the person who was in control of her body as she walked across the grass onto the pavement, that she's never made that claim, and that without that, we can't bootstrap the argument into this case.
That's right, Your Honor. There's no evidentiary foundation for that. And I'd like to point out, three of the cases that I referred to, the Capasso case where the court said a failure to negotiate a change in topography is not in and of itself a hazard. That's the incident where plaintiff was stepping from the asphalt street onto the abutting grass. It was an 8 to 10 inch drop there, fell, and that's how the court ruled there. In the Witkowski case, the plaintiff stepped off the side of a sidewalk into grass and sustained injury. And then finally, the Fourth Department case, Squires, where the plaintiff was stepping over a curb as she walked into the courthouse. The court there found, she was stepping over the curb. There was no defective condition. It was just a height differential that she failed to negotiate. And that's the exact issue we have here.
I think we have that argument, counsel. Is there anything further?
No, unless there are any other questions from the court, I will rest on my papers. Thank you.
Very good. Thank you.
Good morning. My name is Irk MD. May it please the court. I'll try to be brief here. Valerie Meldam was visiting her daughter and bringing back her grandchild. And she and her husband parked in the parking lot. They went directly.
Well, we understand that there's now, I think we all have read the record. Okay. We understand that there was a walkway that she could have used, but it was blocked. That's the argument, right?
Correct.
There was a car parked there, and it wasn't unusual to have a car parked there, which stopped her from using it. That she walked across a grass area.
Correct. En
route to her car. And at that point, she tripped and fell as she was moving from the grass onto the pavement, which was at a different elevation. Your opponent raises the question that the plaintiff herself needs to testify that it was the difference in elevation and her inability to see it because of the grass that caused the fall. And without that, we can't bootstrap a cause of action based upon what other people saw and thought.
In our papers, we had a landscaper who would go out there and he would indicate that it's a difference when you're walking off the height as opposed to going on to the surface of the parking lot. And here, our client testified, as I recall, that she tripped with her toe on this black pavement. And she didn't realize, it's a whole different animal when you're going up as opposed to going down.
So if we comb the record, your argument is going to be that the plaintiff did in fact testify that it was the height elevation that caused her to trip and fall and injure herself, and therefore there is a basis for a presentation to a jury in this case.
That's correct, and that's what happened when she injured her knees and her shoulder and hit her head down on the pavement.
We'll take a look at the evidence of the case. Anything further, counsel?
That's all I have.
Thank you. Case 151, Jones versus Town of Carroll. Counsel, proceed.
May it please the court, Alan Knopf for Appellate Sealand Waste. The town zoned out landfills in 2005 and then, as a backup plan, passed the 2007 law at issue in this case, since the Jones landfill was grandfathered under zoning as the Court of Appeals found in 2010. So really this law affects one property. Everything else had already been zoned out. This court's 2014 decision gave us a roadmap as to how this issue should be determined, whether validity of the 2007 law. And the court said that the law was a health and safety measure so that there was no collateral estoppel on grandfathering under the zoning law, and the court said that even a non-conforming use could be terminated in a reasonable fashion. But the court said that, well, we've got the fifth cause of action for Jones, which later Sealand intervened and joined in, for unreasonable, arbitrary, and capricious legislation. And also there's the first cause of action for substantive due process violation, which would require showing of a deprivation of a vested property interest, which Jones had as found by the Court of Appeals, and showing the challenged governmental action was without legal justification. And in 2019, this court held that summary judgment really shouldn't be granted to either side, and we needed a trial on those two causes of action. There's another cause of action for regulatory taking, but that would require a second trial in the unlikely event this court did not grant our appeal. So here the plaintiffs have met both of these tests because there's no doubt that the 2007 law is not a true health and safety measure. Rather, it's based on pretext and clearly erroneous findings in order to cave into public pressure and county officials in order to stop this project, since it is the only property affected. Everything was already zoned out. And while there was a bench trial, this court can make its own findings, and frankly, there really aren't disputed facts here. It's really a matter of applying the law to the undisputed facts. So whether or not the town can validly zone out landfills isn't the issue here. We just have this one property that is prohibited from operating, and this also, I'll get to later, is inconsistent with state law, preempted by state law, and finally runs afoul of the special facts doctrine because we were targeted, or the Joneses were specifically targeted by dilatory tactics. So first, as to the unreasonable and arbitrary nature of the law, as the Court of Appeals said, every enactment under the police power must be reasonable. And we cited heavily from the Goldblatt U.S. Supreme Court decision that says you've got to look at the menace against which the law will protect, the availability and effectiveness of other less drastic steps, and the loss to the appellants, whether the interests of the public require the interference, and whether it's unduly oppressive. Well, here it is unduly oppressive. There's really no menace at all. Again, it was caving into the public.
Does it matter in this particular case? We got the trial court who's crediting the testimony of the town board members, right? And the town board members are talking about the town having prior problems. I think there were contamination of 2 municipal wells, one by a landfill, in fact, and one by a factory, and that the town board members were concerned that, hey, look, we dodged, I think the language was something along the lines, we dodged a couple bullets here, let's not let that happen again. Isn't that a legitimate interest that the town board members are expressing, and isn't it important for our purpose of review that the court below credited that testimony?
Well, Your Honor, no, Your Honor, because no one disputes that the town wells were threatened. There was an unlined, a town dump that was started way before the solid waste regulations, and there was also the Keywell Superfund site that leaked trichloroethylene. So they had 2 major problems right near their well, or their well field, and it was a problem for them. But the undisputed testimony at trial showed that the town's well field is in the Jamestown aquifer, and that goes in one direction. We're 5 miles away on the other side of town in a separate aquifer where the water goes in a different direction. So it's impossible, and it's undisputed, impossible for contamination from this landfill, if it ever could happen. And again, under the modern double liner requirements, it just isn't going to happen. And if it did, they'd catch it and could deal with it. But so there really was no, yes, were they rightfully concerned about their water supply? They were. But this had nothing to do with it. And Goldblatt says, let's look at less drastic steps. Well, what could they have done? They could have said, the east side of town, no landfills, nothing near our water supply, and the other side of town, hey, there's no need for it. And also add that the Department of Health actually enacted or promulgated regulations to protect the water supply. I think the town actually, they didn't even seem to remember these regulations were there. But they did have special regulations to protect their well field. So I don't, it's all a pretense. Yes, they had a valid concern, but it had nothing to do with this project, especially when this law affected one property. It was targeted at this one property.
And that's really kind of the essence of your argument, that the 2007 law was targeted really for this one property, and there are no other properties going to be affected.
Yes, Your Honor. Yes, Your Honor.
I think we have that part. Anything further?
Yeah, actually I have a lot, but I'll try to move.
There's only so much time, Counsel.
I understand. And I'd say that the supervisor testified. Question, so the 2000 law was sort of a backup plan? Answer, yes. Question, in case you lost on the 2005 litigation? Answer, yes, yes. There's just no doubt at all as the purpose here. And I guess I won't go through all the findings, but they made these findings. They just plagiarized the foreign local law that was going around. Ellery used it and was struck down by Supreme Court, and it went up to this court and it was affirmed. Saying it's impossible to determine groundwater flow. It's not impossible. I've been doing it for, geology's been around for hundreds of years, and the town used it. It's common. It's about half of what I deal with in my practice. We deal with geologists mapping groundwater, and groundwater is important, but again, it's not a threat here to the town's water supply on the other side of town. They say correction of pollution may be very expensive or impossible to achieve. Well, you can clean up sites. We do it all the time. And again, it's not going to happen here because New York has the strictest regulations in the country on solid waste. And they say that health and safety would be better served by restricting solid waste operations, but they don't restrict here, they prohibit. And that gets to the argument of
There's another solid waste area in the town, right? So to not have two would be restricting, not prohibiting, because there is one.
Well, okay. Well, it was closed. I mean, there was a dump that really didn't meet any of these regulations that they closed down.
And it was problematic.
It was problematic because it didn't meet the modern regulations that our client's landfill will meet. And then, again, the less drastic steps that could be taken, and you could even, they weren't talking about individual wells. They came up with that after the fact, but you could require us to supply a private water supply to anybody who is affected. But there's really no chance it's going to happen. As far as due process, substantive due process protects the individual against arbitrary actions where there's no legitimate reason, wholly without legal justification. And yes, there is a heavy burden here, but again, there's no doubt that, and this isn't really my claim, it's my co-counsel's claim for his client, because it's undisputed they have vested rights, as the Court of Appeals found, and this court also reiterated in later findings. In the findings, 2 through 6 tried to justify the law on the basis of the Chautauqua County landfill was a great thing, and okay, that's fine, but it's got nothing to do with health and safety. They have a very limited window to be able to have a valid law that can take out a non-conforming use. And that's, so economic concerns, appeasing the public, though, even if those were legitimate concerns for local legislation, which they're generally not, here they don't pass muster. And the local health regulations, the Court of Appeals said, you only pass local health regulations if you've got something unique. And there's nothing unique here, especially when they already had health regulations. So I think as far as I get to the preemption argument.
Counsel, you should begin to wrap up.
Okay, that it is preempted because prohibition is not regulation, and then the special facts doctrine has been extended, and this court in the Golisano case goes way beyond, we definitely meet the test here. And finally, standing, it really doesn't matter because Mrs. Jones has standing, but this court determined that when it allowed our client to intervene and said we had a substantial interest. So we ask that you strike down this law so we don't have to get to the second trial on how many millions of dollars the town has to pay us. We would, or Mrs. Jones, we would like to move forward with a very sound and environmentally safe landfill.
Thank you, Counsel.
May it please the court, Gerald Brodigan for the Jones family. I'll just add a few things if I can, Your Honor.
Please.
Your Honors, first of all, with respect to the water, the consideration that the water was going to be affected, the Jones facility had already reached capacity with an old clay liner. All of the town witnesses agreed that there had never been one problem with any of the surrounding wells. That was just a farce. It was a sham. It was a pretense. They weren't going to have water problems as a result of that. They hadn't had any already, even with the substandard, now no longer environmentally approved lining that was on the previous landfill system. Secondly, the town didn't really view this as health and safety. They viewed it as a substitute zoning law. And you'll find in the record that at one point there was an application just to improve the facility a little bit. Put a new bathroom in, put a new fence around it. And the town board officials told the zoning officer not to approve it. Why? But it has nothing to do with health and safety. It has everything to do with the fact that they were doing anything possible to try to discourage Alan's client from putting in a landfill. Your Honor, I think it's very clear that this was not a health and safety law. It was simply, as I said before, it was a sham, it was a pretense, it was an insurance policy, if you will. It was devised by prior town council, my friend and unfortunately deceased now, a very clever and very intelligent attorney, and he used it as a backup plan. Turns out they needed the backup plan because the Court of Appeals eventually ruled that there was a vested right to use the property for a landfill. The preemption argument, everybody agreed that the DEC has the most stringent rules in the nation. There's safeguards upon safeguards here. There's not only a double composite liner, there's monitoring wells, they're tested all the time. This is in a remote part of a remote township with just a few houses around there. And there's just really no practical way anybody's going to be damaged by this, and the DEC took all that into effect. And finally, my clients do have a vested right. It's been held that way by the Court of Appeals, affirmed by this court, and it was taken from us without due process.
Thank you, Counsel.
Good morning, Your Honors. Jeff Stravino from Hodson Russ. I have my colleague Cheyenne Freely here who worked with me on the brief. I'm here on behalf of the respondent, Town of Carroll. I was not involved in this case until about 8 months before trial because of, unfortunately, Mr. Webb's passing, but have gotten to know the area and everything that happened very well because, as I think you know, Judge Hanlon held an 11-day trial. There were 155 exhibits, allowed any and every witness to be called, whoever the plaintiffs, wanted. And frankly, one of my big arguments before trial that I don't make in the brief, but I think is an important point is, I didn't think any evidence after the passage of the 2007 law is relevant. And you're going to read, and if you read in their briefs, they talk about Dr. Richards, and they talk about Mr. Carey, and they talk about Mr. Primo, et cetera. None of these people were available or there before 2007 for the town board. So I think that's something that's really relevant. I think also clearly the standards and the prior case law completely favors the town. You know, a court may not substitute its judgment for a legislative body. That's clear. This court respectfully should not disturb an appeal unless it's obvious that the trial court's conclusions cannot be reached under any fair interpretation of the evidence. And also, this court must view in the light most favorable of the court below to sustain the judgment. We do argue, and I do firmly believe, that Sealand doesn't have standing. I won't go into that. We have that in our brief. But I think it really was relevant that it did not come out until trial that Mr. Bree, the principal of Sealand, was signing documents under penalties of perjury where he was representing the DEC that he was the owner of the property, which he was not. I think also that the 2007 law, as courts have said, has an exceedingly strong presumption of constitutionality, and it should be struck down only as a last resort. Here, we believe that the plaintiffs cannot establish both deprivation of a vested property interest. Sealand doesn't have one. That already had been decided by this court back in 2019, and that the challenged action was wholly without legal justification. The 2007 law is different than the 2005 law. It's a health and safety law. The point about water, I think, and as we've seen it in our daily lives now in terms of PFAS and everything that's going around the country, back in 2007 was a big issue. Presiding Justice Whalen, you pointed out about the wells and already issues that have been in the town. And I think it's really interesting if you look at the record, pages 692 and 696, it was Dr. Richards, and he admitted that when he considered what was the town water supply, he didn't think about all of the town residents who are on wells. So the fact that Mr. Knopf argued about the Jamestown aquifer, there were a bunch of people and the people around the landfill who are on wells. And so I think that's really significant. Another point that Mr. Carey, one of their experts, Record 904, admitted was that C&D landfills can emit odors. And he also admitted, Mr. Carey also admitted, he didn't evaluate the impacts of the Martz Coal Observatory. So I think, you know, all of these points, and we make them in our brief, and I don't want to be here, and I'll keep it under a minute now, but I think there were so many issues that the town board considered and was concerned about between traffic, odors, property values, air quality, noise, visual aesthetics, the Martz Coal, the heat generation that came out from that. And I mean, Martz Coal, NASA and Cornell and other state universities use Martz Coal and their telescopes and the visions that they get from space as part of their curriculum and for results in the work that they do. You know, there was clearly, we believe, a legitimate government purpose to promote public health, safety, and welfare. Courts have held prohibition of private landfills within the town borders as a valid exercise, and we think that the record shows there's a reasonable relation. The county landfill also is very relevant. I know there were questions about that before, and we had people come to the trial who were not our witnesses, but who we subpoenaed, the former county executive at the time, his testimony's in the record, Natalie Whiteman from the Chautauqua County Department of Water, who also testified about the issues that were there and being investigated. And respectfully, while I'm a colleague and friend of Mr. Knopf's, I think the facts are relevant here. It's not just the law. And the facts that existed at the time back in 2007 show that the town was very reasonable and it had a conceivable basis for what it decided. So thank you very much, and we respectfully request the court uphold the lower court.
Thank you, counsel.
Thank you.
Case 152, Wilberger versus Allen. Counsel, proceed.
May it please the court, Brendan Little, Lippis Mathias, on behalf of plaintiff appellant Virginia Wilberger. At the trial court, Ms. Wilberger sought emails and text messages in order to prove her claims that the defendants breached their fiduciary duties. The defendants refused to produce that electronic communication, relying on saying they were immune from production based on attorney-client privilege and the common interest exception to the waiver of attorney-client privilege. However, no trial judge has ever reviewed those emails or electronic communications. Without an improper in-camera review of those electronic communications, Ms. Wilberger will be forced to accept her adversary's position that those electronic communications are immune from production.
Okay, so help clear up some of the confusion I think that's in this record, okay, in that there was a related case where the same emails were at issue, and the court made some pronouncements about them, but you're saying there's no proof in the record that the court actually had those particular documents, is that right?
That's correct. There was a prior litigation that involved some of the similar parties but different issues. The first action, which this court actually reviewed about a year ago, related to whether the independent trustee was properly removed. My client, Ms. Wilberger, was a defendant in that case. Here she's a plaintiff in this case, alleging that the co-trustees breached their fiduciary duty. Those emails were produced to Justice Walker in the first action. Justice Walker ordered them to be produced in camera. We don't know whether Justice Walker actually reviewed those emails. He then granted summary judgment to the plaintiffs in that case without referencing the emails whatsoever.
And he made no particular findings about any of those documents.
And that's correct, and that's the important point, is that when we moved to compel, and actually we had a pretrial conference, and my affirmation indicates that Justice Walker in the commercial division has a meet and confer requirement regarding this issue, and Justice Walker said, no, you don't have to go through the meet and confer. I know the issue, please bring it before me. We moved to compel.
And the argument is that there was language that he implicitly indicated that he had reviewed those.
On re-argument, he said, well, yes, I guess if it wasn't clear, it is, I guess I'm saying I impliedly did that, but a grant of summary judgment to one party on a removal of an independent trustee and whether someone breached their fiduciary duty in a summary judgment issue, those are two totally separate issues.
You want somebody to look at them in particular and make some kind of judgment about whether or not that they are protected communications, and if they aren't, give them to you, and you believe that that hasn't been done to date.
That's correct. Justice Chimes is now assigned to this case. We ask that the court remand that back to Justice Chimes to do an in-camera review. We're only talking about 13 to 15 communications. This is not thousands of documents. Without a trial judge looking at these documents in camera, Ms. Wilberger would be forced to accept that these are in fact immune from production, and she essentially wouldn't have her day in court. So we ask that you remand this back to the trial court for a review of those cameras in email and then, or in camera, and then get a decision from the trial court.
Thank you, counsel.
Thank you, Judge.
May it please the court, my name is Joshua Glasgow. I represent defendant respondents Timothy Allen, Beverly Britzolaro, Louise McBean, Terrence Welch. That's a group we refer to as the family trustees. And I'd like to start with the Supreme Court's own words. This is a direct quote. After having the benefit of reviewing the documents, the court did not order them to be turned over to plaintiff's counsel, instead granting summary judgment. In short, the court implicitly denied the motion to compel, and to the extent it's not clear, it does so now. So, despite the Supreme Court's clear explanation of exactly what it did, I looked at the documents, I did not order them to be turned over. Ms. Wilberger continues to argue that no in-camera review has occurred, and that's simply not the case as reflected in the record. The quote that I read is from page 656 of the record. I omitted a citation, but otherwise that's exactly what the Supreme Court said. You don't have to take my word for it, you just have to read the record.
And so we have to decide what those words mean exactly, whether it meant that the court looked at them, made judgments about each and every one of them, and disposed of them.
Yeah, that's right. And so, I think the Supreme Court statement here, after having the benefit of reviewing the documents, puts to bed any argument that the Supreme Court didn't look at these documents, right? And if you look at the reply brief, I think it's important because it narrows the scope of what's at issue in this appeal. So we initially briefed this appeal as if we were briefing the merits of the privilege issue. We talked about, the various doctrines. In the reply at page 13, Ms. Wilberger says, again a quote, Wilberger is not asking this court to overturn the trial court and compel all the documents respondents have asserted privilege over. Instead, Wilberger asks this court to reverse the denial of her motion to compel and remand with directive to the trial court to conduct an in-camera review of the purportedly privileged communications. That's already happened, right? A remand from this court do the in-camera review, that's a waste of judicial resources. The court specifically said, I already reviewed the documents. There's no dispute that they were submitted in camera. You can look in the record, and the transmittal emails are copied, the confirmation emails that we sent them are copied. There's no dispute that the exact same documents are issued.
I think you wouldn't disagree, though, that the court's language on the review, more specific language about what documents were reviewed and whether or not privilege applied, that would have certainly been helpful in this case.
It certainly would have made my life easier, but that would have been sufficient, but it's not necessary, right? So the Supreme Court says, again at page 656, while it did not render a formal decision on privilege in the prior action, it did not rely on any factual inaccuracy in denying the current motion. So it's saying, look, privilege is at issue. I looked at the documents. I didn't order them to be turned over. I made this implicit ruling. The Ms. Wilberger's brief a few times mentions the idea that we're kind of taking liberties with the record by suggesting there was an implicit ruling. That's the Supreme Court's own word. It said implicitly decided. That's what the Supreme Court did. But getting back to the reply brief at page 13, Ms. Wilberger also says she wants a document-by-document determination as to each privilege asserted. And there's no authority cited for the proposition that a Supreme Court has to do a document-by-document, privilege-by-privilege explanation in order to pass muster before this court. And imposing that kind of requirement, I submit, would be extremely burdensome to the Supreme Court. There aren't that many documents at issue in this case, but we've all seen privilege logs that are hundreds of pages long. Enforcing a rule that you need to explain by document what happened would really be wasteful. And I'd also point the court to CPLR 2219. That contains the requirements for what the Supreme Court's required to place in an order. As to explanation, it says the Supreme Court's required to provide such detail as the judge deems proper. Certainly there are one-sentence orders that get affirmed by this court all the time. There's certainly nothing controversial about that.
Counsel, I mean, the Supreme Court didn't even go as far as saying, I found no, or privilege applied here, the attorney-client privilege. He didn't even say really what privilege he said applied, or that he impliedly said, was implied. I mean,
yes.
So I guess that there's, it limits our judicial review if we don't have any explanation. And these apparently are important documents. Well, I mean, I don't know the answer to that because, of course, I haven't seen the documents, but, you're fighting about them not in the last case and this case.
Yeah, I'd also submit that the reason that you haven't had a chance to review them is because plaintiff didn't arrange for in-camera review by this court. That's something that this court has ordered in the past. I cite the Albina case. That's a decision from this court, which expressly holds that when a plaintiff does not arrange, when an appellant does not arrange for in-camera review under these circumstances, appellate review is waived. And I don't see any distinction between that case and this case. The other point I'd make is that, counsel mentioned today there's a different judge assigned, and I think that's what's really driving this appeal, right? It's not good for the courts in general to have a different result reached when a new judge is assigned. And I think, to the extent...
Maybe a good result for one of the parties, but your argument is it's not good for the court system.
That's right. It would be bad for us, it would be bad for the court system, maybe it would be good for plaintiff.
You don't know that it would be bad for you.
Right, that's right. That's right. But I do want to say, the way that we got here, the reason that we had this, granted unusual procedural posture, is what happened in the prior action. So we moved for summary judgment. After we moved for summary judgment, Ms. Wilberger and the parties aligned with her filed some motions to compel. We moved to stay discovery. The Supreme Court granted that motion and said, let's brief summary judgment. We're not going to do any additional discovery at this point. Then we had argument on the summary judgment motion, and in that argument, Ms. Wilberger argued, Judge, you can't rule on the summary judgment motion before you decide our motions to compel. And I quoted in the briefs, there's 3 separate times the Supreme Court clarifies. So you're asking me to order in-camera review, decide whether they should be disclosed before ruling on the summary judgment motion. That's at page 498, 499, and 502. 3 times, counsel confirms, yes, that's what I'm asking you to do. And that's what the Supreme Court did. It ordered in-camera production, no dispute about that. It looked at the documents. It did not order them to be disclosed. So in the new action, when the motion to compel comes up, the judge very quickly denies it, says, I already did this, why are we here? And then they filed a motion for reconsideration, and the judge explains in greater detail. He says, look, I didn't render a formal decision on privilege in the prior action, but I implicitly decided that issue, and to the extent not clear, I do so now. So
No, we understand the language, Counsel.
Thank you, Your Honor.
Thank you.
May it please the court, Joe Zdarsky appearing for the trust protector, Mr. Champeau. I would endorse everything that my colleague here has said. I think that this is like the fourth time that counsel wants to go back to the well and try and get some documents that have been ruled protected by privilege. And the privilege, I think, is very clear. Courts always decide, not always, but usually decide cases on privilege by classes of documents. They don't go through every single document and issue a ruling. In my case, there's one document in particular that was a draft of a letter that he sent to counsel for opinions on whether or not he should send the letter. He got those opinions, then he decided not to send the letter. I mean, it's a clear attorney-client privilege ruling, and those letters were produced for in-camera review anyway. And I was comfortable that the court had reviewed them and took that into account when it issued the summary judgment ruling the first time around. So I would urge the court to affirm the court below.
Thank you, Counsel.
Thank you.
Case 153, Jones versus City of Buffalo. Mr. Lee, can you hear us?
Yes, Judge.
Very good. We can hear you. Mr. Stocker, can you hear us? We can't hear you, Ms. Stocker.
How about now? Can you hear me?
We can hear you now, and you can hear us, I trust?
Yes, Your Honor.
Very good. Please proceed.
Your Honor, just briefly, in the record, it's clear that the city and the officials knew about Judge Nowak's order to show cause, along with not demolishing the building the day before demolition took place. Judge Nowak took extraordinary efforts to visit the site the morning prior, or the morning of the demolition, noticed there was the construction company at the site, and proceeded to email and phone call the city's attorneys that he specifically did not want the property to be demolished. We're asking for the lower court to be reversed and a hearing set down for damages.
Thank you, counsel. Anything further?
No, Your Honor.
Thank you. Mr. Lee.
Good morning, Your Honors. David Lee, Assistant Corporation Counsel for the defendant respondent, City of Buffalo. I don't think I'm oversimplifying the city's argument when I say that the plaintiff simply has no cause of action, no legally cognizable cause of action, because the order to show cause signed by Justice Nowak does not contain a temporary restraining order. We know that just by simply reading the order to show cause. There's no TRO. And to the extent there's any ambiguity there, while Justice Nowak was deposed in this action and he was directly asked, is there a TRO? His response, and I'm summarizing, this isn't like I'm not quoting him here, but no, there is no TRO. And then he also
Well, it's pretty obvious on the face of the document. It isn't, counsel, that there is no TRO, but I think, wasn't it contemplated that, I mean, for purpose of seeking the relief on the order to show cause, that the relief couldn't be granted if the building was demolished? And there was a return date on the order to show cause. Does that matter?
I don't think so, Judge. I mean, that's why you have that's why normally orders to show cause would have a TRO in them. And if there is no TRO, then there's no order prohibiting any particular conduct.
And is part of your argument that the city, in going forward with the demolition, wasn't aware of the return date on the order to show cause and that it had been granted when it was demolishing the building?
Well, I think the record might not be completely clear on that point on when the order to show cause was received by the city relative to the time the building was demolished. I mean, you have Judge Nowak's email, I think that came into the Corporation Counsel's office at 9:55 a.m. on the day that the demo was performed. It also says in the record that at least by 10:30 a.m., so this is a half hour later, that the building was already demolished. So, I mean, if anything, the record shows, I think that the building was down, or at least the demolition was underway before the city ever received Justice Nowak's email regarding the order to show cause.
And Mr. Lee, excuse me, the defendant, Hannah Demolition, they were not named on that order to show cause, is that correct? So how would they have noticed?
That's correct, Judge.
I don't think Judge Nowak indicated that he went up to Hannah and said, hey, I'm going to stop this. There was any testimony from Judge Nowak to that respect, isn't that right?
No, there was no testimony. That's correct, Judge. There was no testimony to that effect, and there also was nothing in his email about that, about how he said he was there, and that Hannah was sort of getting ready to do the demolition when Judge Nowak stopped by in the morning. But no, he never said anything in his email about how I went up to him and said, no, you guys got to stop. I'm going to sign an order to show cause stopping this. He never did that.
Essentially, your argument is there was no temporary restraining order, and that's the end of the argument.
Yes, well, in a nutshell, yes, because how can the plaintiff have there's just no legal cause of action here. I mean, I don't see any legal basis for the plaintiff's trespass and trespass-related claims if there's no TRO. And
I think we understand that argument, counsel. Anything further?
No, that's all, Your Honor.
Thank you, counsel.
Thank you.
Case 154, Bane versus Lease and Save Corporation. Counsel, proceed.
Thank you, Your Honor. Good morning, Your Honors. Good afternoon, maybe. Good morning still. I represent the defendant appellants here. I'll start by dispensing with the toll versus suspension argument. So sooner or later, that'll be settled, but it's just included in everything. Beyond that, Your Honor, we appear to be down to only one argument in this one, and that is whether or not it was an entire displacement. That seems to be the argument that they've made. To be honest, that wasn't put in our reply. I just read that yesterday. But it is, in fact, a valid argument that they were not entirely displaced. This court, in 2006, in the Eisleben, Eisleben versus Dean case. That's 24 New York Sub 3rd 815. This court held that we agree with the defendants that the court erred, and we therefore reverse the order insofar as appealed from. Here, the contract between the defendant and the property owner was not so comprehensive and exclusive that it entirely displaced the property owner's duty to maintain the premises safely, and that such defendant owed a duty to the plaintiff. Though the contract required round-the-clock monitoring and of the condition of the premises, it also gave the property owner the right to request additional services, reperformance, and employees of the property owner monitored the performance of the contract. Well, Your Honors, in the contract, at pages 50 and 51 of the record, those exact things exist. The same things exist there. That the property managed, that the snow was to be put in areas that were prescribed by the property management. And this is M&T Bank, so there's a property manager for each and every property. They talk about in the event the property manager disagrees with the company's assessment, the company may, and then it goes through a whole selection of things to do. This was not, there are 6 or 7 different spots where the property manager has the right to, ask them to come back, among other things. There has to be a 24-hour number. Your Honors, this is an Espinal case, right on the nines. And unless the court has questions, that's really all I've got.
Very good. Thank you, counsel.
Thank you, Your Honor.
morning, may it please the court. To prevail in this appeal, defendants have to show that the two agreements, the M&T and the Denco agreement, and then the Denco subcontract with RJS, now has utterly defeated plaintiff's negligence claims. Utterly defeated. And as you know, that the claims that plaintiff is asserting are a fact. And if you look at those two agreements, to a certain extent, I'll agree with Mr. Adams that there may be an issue here about how much they preempted it all. But the whole point now is Espinal. Espinal says that, sure, you breach a contract, third party rarely can't sue unless you can show an Espinal factual scenario. So to prevail, they now have to show that Espinal, the three, especially that instrument of harm, now has been negated by the contract, and the contract doesn't negate those facts. Now, to the extent that quickly, there may be an argument here, I think, that could be made on summary judgment.
Yeah, this is a 3211 case.
This is a 3211.
Yeah, documentary case.
And
yeah.
I think that makes all the difference in the world, Your Honor.
And I think, didn't the court below essentially say that this may be...
She didn't write a decision, Your Honor.
Okay.
But I think the briefs, the memos, the memorandums of law pretty much nail that, both sides.
Very good.
Unless there are further questions.
No further questions, counsel. Thank you. Case 155 and 156, Christler versus Irk MD.
May it please the court, John?
Counsel, first of all, before you get started, I understand that there was a request to argue, which was not received until yesterday. My understanding is you have no objection to your opponent arguing today?
That's correct, Your Honor.
Thank you for your courtesies, counsel. Proceed.
Thank you. John Daniel on behalf of the defendant, appellant Clyda Health. As you may know, this is a case arising out of a surgery performed by the co-defendant, Dr. Emmett Merck, on the plaintiff on October 19th, 2019, and the postoperative care after that surgery that culminated in the diagnosis of a bowel perforation. Relevant to this appeal, plaintiff has asserted a negligent credentialing claim against Clyda Health. We are here, Your Honors, asking this court to modify the order of Judge Nowak that compels Clyda to produce for a deposition a representative with any knowledge of prior incidents or complaints involving injuries to patients as a result of surgeries performed by Dr. Irk before October 19th of 2019. And we don't dispute that under the Byrk versus Kramer case that the plaintiff is entitled to depose a Clyda witness with knowledge of similar prior surgical outcomes, as long as the knowledge is not obtained strictly through a quality or credentialing process which is protected. The problem here is that the order as it stands is far broader than that. It compels us to produce a witness with any knowledge, incident involving surgery to patients as a result of Dr. Irk's surgery. That order taken literally encompasses every surgery Dr. Irk ever performed, because every surgery...
But counsel, I'm struggling with this because that's your interpretation, that this is an unlimited direction, whereas the court seemed to indicate you have control over who you produce, as opposed to the court limiting whether it be a supervisor or manager. And then there's sort of a rule of reason here in any deposition as to how far the questioning is going to go.
Right, and I think it's true that we could, we could have and would have produced witnesses in an effort to try to go down this road and provide information that's relevant. The problem we have is that we don't want to be in a position where we're in violation of a court's order because we haven't produced a nurse who was aware of a routine surgery that involved no complication whatsoever that occurred in 1992. And under the current wording of the order,
Counsel,
that argument could be made against us.
Let me follow up on Justice Delcathy's question, because I have a similar concern. Is what you're saying that if under the current language that's telling you who you need to produce, you're saying, first of all, it's too broad. It doesn't limit it in time or in the class of people to be produced, right? Supervisory, et cetera.
Or the type of information.
Yeah, the cases that
Right.
might have been involved, right. Is it your concern that if under that language, you were to produce a person that you choose for the deposition, and that person comes in and testifies as to some of these things, you identify somebody, and they come in to testify as to some of these things, is it your concern that they're going to be asked questions that maybe go far afield from what is appropriate to be asked during the deposition?
No, it's our concern that in not producing other witnesses encompass.
Well, you've got to produce one to start, right?
Yes.
Right, you've got to pick some, they're not asking you to produce find everybody and produce all of them. They're saying, pick one that fits this definition, bring them in for questioning. Are you saying that your fear is that you can't find one?
No,
I'm just trying to understand where the problem really lies. That's why I'm asking the question.
The problem lies is that the order is so broad that if we didn't produce certain witnesses, and it's not a witness, the notice is for a witness or witnesses with knowledge of any injury from any surgery over 30 years, and that's...
So you're helping me now understand this. So is your concern that witness or witnesses, your concern is if you find a person that fits this category and you bring them in for a deposition, if there are other people that also fit the category, that you might be found in violation. Is that your concern?
Definitely, yeah.
As opposed to picking one person and moving forward, starting the deposition cycle, right? I mean, this is what typically happens. You identify a person that would be an appropriate person to testify, you bring them in, and that leads you to maybe some other witnesses. You're saying if you show up on the day of deposition without all of the witnesses, you might be in violation.
Right.
I think I understand that.
Yeah.
Thank you.
And that's really, and with respect to the time limit, Your Honor, in the papers below, counsel for the plaintiff, they conceded, we proposed a 5-year time limit going back, and that was, that's a short period. It was an arbitrary number picked by us. We weren't trying to exclude reference to any of these other cases that they alluded to, but they conceded in their papers below that a 15-year time limit would be a reasonable accommodation on their part to that request, so we don't have to go back to 1990, 1989, when Dr. Irk started working at Kaleida. And so we submit that there should be that 15-year time limit as well. And that was one, on the motion to re-argue, that was a modification that Judge Nowak implemented with respect to the demand for written complaints, which is not the subject of this appeal. He did not go back 30 years with respect, he did not go back to just 15 years with respect to witnesses. He said with the witnesses, it should be the whole time he worked there. The plaintiff has conceded that the 15-year time limit would be a reasonable accommodation on that.
But you're asking for 5 years here.
We did
But
propose
you're abandoning
5.
that now.
Pardon me?
You're abandoning that now.
Well,
and then
we proposed that in the papers below, certainly.
But to be clear here, this is staged up because you refuse to provide any witnesses. There's motions before the court, and the court has to evaluate this and comes up with this order directing you to produce a witness that fits the court's criteria, and isn't the question before us whether the court abused its discretion in fashioning that remedy, that discovery remedy?
That is the standard.
But now you say, in your papers before us, you say the court abused its discretion by not limiting it to 5 years, and now you're saying, well, it could be 15.
Well, that would be an accommodation between.
Today, you
5
say
and
that.
30,
But the same thing
yes.
about the nature of the type of surgeries that the plaintiff can explore. Do you still stand on your brief where it can only be laparoscopic bowel surgeries?
No, we've conceded.
You conceded
That argument below that. it
So
could be
what's
broader
the
than
issue?
that.
What is the issue? Just that you want us to direct that it be a supervisor or manager? Is that the only thing that's left?
Well, I mean, the issue is the 30-year time period and the fact that the order compels us to provide a witness with knowledge of any injury from any surgery, which is every surgery that Dr. Irk ever performed results in an intended injury. What we're talking about here is adverse outcomes, injuries to the bowel or other visceral organs.
Counsel, I disagree with that. I think they're looking for notice people, notice witnesses. What do you know? What kind of documents do you keep? What kind of reports or lawsuits have you compiled? They're not asking you to go poll the world about the outcomes, and nor could the court tell you to do that.
It's notice about similar adverse events, though. It's not about, and the order, I keep coming back to, I think the order, as broadly as it's stated, goes beyond that.
I think your concerns might be a little, overly concerned,
The counsel, as I understand the underlying facts in the case, though, it isn't just the perforation. It's the fact that it went untreated for 10 days. It was the follow-up care. That was part of, that's why maybe the court didn't limit it to just laparoscopic surgeries.
I mean, that is a claim in the case.
Right.
Against Dr. Irk and others, and Dr. Higbee and other providers. So,
Thank you, counsel.
thank you, Your Honors.
Good afternoon, Your Honors. Dennis Harlow on behalf of Plaintiff Respondent. Your Honors.
Counsel, I'm going to start with a question that still has, do you read the current order, if it were affirmed, to mean that your opponent is required to produce more than one witness?
I do not. The language is very conventional. They're not required to produce every witness in the world with potential knowledge. They're not required to produce a witness that has comprehensive knowledge of every surgery performed by
They're
Dr.
to
Irk.
produce one witness that fits the category outlined in the language that the court provided. And for a deposition goes forward. If additional witnesses flow from that, they may flow from that. Is that your understanding?
That's exactly my understanding, Your Honor.
Proceed.
Well, Your Honors, the standard is clear abuse of discretion. I don't think that there's any colorable argument that there is any abuse, much less a clear abuse present in this order. The modifications that the defendant have requested, none of them have any case law that supports the notion that they're entitled to those particular restrictions. So with that said, if the court has no questions, I'd be inclined to rest on my papers.
Thank you, counsel.
Thank you, Your Honor.